Hello, everyone, and welcome to my presentation on competence reviews and insanity defense and other mental state defenses. My name is Jessica Gondek, and over the next few minutes, I'll be walking you through some of the history, the legal cases, and the ongoing debates about our courts' handled decisions around the insanity defense. Let's start with what we'll cover today. By the end of this talk, you should be able to recognize and define some key legal and psychological terms, understand the concept of the insanity defense, explore two landmark cases, Wallum versus the United States and Frendock versus the United States, and think about the reasons a defendant might refuse to plead insanity, even when it could protect them from conviction. Finally, I'll leave you with a question to reflect on. Before diving into the cases, let's pause on some key terms. These include corpus delicti, decisional competence, the Wallum approach, the Frendock approach, and, of course, the insanity defense. Oop. Sorry, guys, I didn't mean to jump ahead. Corpus delicti is a Latin phrase that means the body of crime. In law, it refers to the principle that a crime must be proven to have occurred before someone can be convicted. It's not enough to just have a confession. There needs to be evidence that the crime actually took place. Decisional competence. This refers to a person's ability to understand information, weigh their options, and make informed choices. In the courtroom, decisional competence is a big deal when someone is deciding whether or not to use a defense like insanity. The Wallum approach and Frendock approach are two different legal standards that grew out of court cases we'll explore in a moment. Each one reflects a different way of balancing society's interests and defendant's personal autonomy. And finally, the insanity defense. This is a legal argument that says a defendant should not be held criminally responsible at the time of the crime. A severe mental illness made them unable to understand their actions or tell them wrong. Now, why does the insanity defense matter? On the one hand, it protects people who, due to severe mental illnesses, cannot be blamed in the same way as someone who acted knowingly and intentionally. On the other hand, it raises questions about accountability, fairness, and public safety. Let's look at our first case, Wallum versus United States. This case set an important precedent back in the 1960s. Judge Bazelon decided that trial courts could require the use of insanity defense even if the defendant didn't want to use it. Why? Because, in his view, society's interest in protecting the public and making sure justice was done outweighed an individual's choice. The reasoning went like this. We cannot convict someone who is morally blameless due to mental incapacity. If someone truly did not understand what they were doing or couldn't control their actions because of severe mental illness, convicting them would be unjust. Under Wallum, no one could be found guilty of a crime if their mental state meant they could not be held responsible. But there was a catch. This approach didn't give much weight to the defendant's own wishes. If the court thought insanity applied, it could be forced on them. This raised concerns about autonomy, dignity, and whether people had the right to make their own legal decisions, even risky ones. Eventually, this approach was overturned in United States versus Marble, but it set the stage for further debates. Now let's fast forward to 1979 in the case of Frendock versus the United States. This case swung the pendulum in the opposite direction. The court here ruled that if a defendant is found competent, then their choice about whether or not to use the insanity defense must be respected. In other words, the law recognized a competent defendant's right to autonomy. The key here was the idea of competence evaluation. If a defendant was competent, meaning they could understand the consequences of their decisions, reasons through their options, and make a voluntary choice, then they had the right to refuse the insanity defense. If they were not competent, then the court could step in. This marked an important shift in focus. Instead of prioritizing society's protection, Frendock put more emphasis on the individual's freedom to decide. It respected personal agency and recognized that forcing a defense on someone might actually cause more harm. Let's compare the two approaches more clearly. Under Wallam, the court could impose the insanity defense against the defendant's wishes. The main focus was protecting society, ensuring no one was wrongfully convicted due to mental illness. Competency at the time didn't matter as much. The emphasis was on the crime and society's view of justice. Under Frendock, the opposite view was true. The defendant's autonomy was the central value. If they were competent, they could refuse the insanity defense, even if it meant facing conviction. The court had to carefully evaluate their understanding, reasoning, and voluntariness before respecting that decision. So, why would anyone refuse the insanity defense? It seems counterintuitive at first. After all, it might save some of them from a prison sentence, but there are several reasons. First, confinement under insanity verdict can actually last longer than a prison sentence. Someone found not guilty by reason of insanity may end up in a psychiatric hospital for decades, sometimes longer than the prison time that they have received. Second, treatment in jail or prison may actually be preferable to some defendants compared to psychiatric confinement. In some cases, psychiatric hospitals can feel more restrictive, with fewer rights and less predictability about release. Third, defendants may want to avoid the stigma of being labeled mentally ill. Mental health stigma can have lasting effects on a person's identity, reputation, and relationships. Fourth, there could be collateral consequences, like losing legal rights such as right to own property, vote, or make decisions if one is deemed mentally incompetent. And finally, for some defendants, refusing the insanity defense can be a way of making a political or religious statement. They may want to be judged for their actions as intentional, not as a result of mental illness to give meaning in their choices. At this point, you can see the complexity on one side. There's society's interest in fairness and protection. On the other side, there's a defendant's autonomy and right to self-determination. Balancing those interests isn't easy. I'd like to point to an informative media source that explores these ideas further. Fox 35 Orlando released a video where a criminal defense attorney breaks down the insanity defense and its applications. If you're curious about how this plays out in real cases, it's definitely worth watching. So, where does this leave us? Courts are constantly negotiating the balance between protecting society and respecting individual autonomy. Should a competent defendant be allowed to make a potential self-destructive choice, or should the court step in to protect them from themselves? That brings me to the discussion question I'd like you to consider. Should the courts start prioritizing the defendant's autonomy during the decisional process of refusing the insanity defense if they are found competent? Or should the courts follow society and their views on protection and justice? Where would you find yourself in this situation? Thank you so much for your time and attention today. I hope this talk has helped you better understand the insanity's defense, the landmark cases of Wallam and Frendock, and the ongoing questions about the competence, autonomy, and justice. I hope you guys have a wonderful week and have a good rest of your day.